Hey Ryan, how are you? It's the end of May, and this has been quite a week. It is a string of losses with one exception, one big exception. So, what happened this week?
Yeah, so major decisions in the courts in which the Trump administration's, I would say, signature policies have been defeated so far. Temporary restraining orders, preliminary injunctions, things like that. But the biggest ones are one, his tariffs policy is held in summary judgment to be unconstitutional and in violation of statute. And that's one court. Another DC court also invalidated his tariffs policy. That's a big one.
So
Second
it's
one,
two, if I remember correctly, this is like first it was one, and then before the ink was dry, the
yes,
second court said they are entering another restraining order on it. So you have two decisions, but those are not yet in effect because they're both stayed. So it is a loss, but for companies out there, the tariffs are still in place because but it's just a whole lot of uncertainty. Legally, you have two courts that said tariffs violate the law principally because essentially the executive branch is overstepping its authority, as I understand it. But I think it's fair to say that those are big losses in terms of where things stand. The tariffs are still in place. So, from a perspective of consumers, in terms of the market, it sort of created all this continued doubt about what's going to happen. Okay,
yeah,
what else is
and
new?
and oh, and then just on that one, I'd also say that the fact that the lower court opinions have been stayed is nothing about the merits. It's just that
Yeah.
the appeals court have placed an administrative stay, which just means freeze everything in place. Don't change anything just yet. Allow the tariffs to be continuing until we, the Court of Appeals, get to decide. So that's the first one. So I think it's a bad sign for the administration, especially to have two courts back to back say that the tariffs are illegal, essentially, because the Trump administration tried to pass them under national emergency legislation that is a very poor fit for tariffs. So that's the first one. Second one in my mind is Ninth Circuit opinion on the massive reduction in force policies across the administration, across the different departments and agencies. Very strategic litigation that is first lodged in a district court in California. The district court in California, on a preliminary injunction, says that this massive reduction in force, sometimes in certain departments and agencies up to over 80% of staff, is in violation of constitutional authority because it's so quantitatively and qualitatively different that it is basically gutting agencies. It's doing things that Congress has not authorized. And then this week, the
By
Ninth
the way, by
Circuit,
the way,
yeah,
just to be clear, same kind of theory, executive branch overstepping
yeah,
the bounds that in terms of this is about sort of congressional power versus executive power, which is when you act sort of unilaterally and by executive order, the courts are saying, no, you've preempted something that Congress has the authority to do, not you,
yes.
President.
Yes, and also
Sorry, and
even no, I think it's a great point, and I'll just add to what you just said, which is elections have consequences. When Trump came into office, he had every right to implement his preferred policies, but no right whatsoever to do so illegally. and
yeah, but
and
also
yeah,
elections have consequences, but so do congressional elections,
right,
right? I
exactly,
mean,
right,
it's not,
right.
there's a lot of different, I mean, that reminds me a lot of times when people say, oh, the court's doing it as anti-democratic. Well, guess what? The courts are part of the democracy,
Right, right.
and the president, yes, elections have consequences, but there's two branches of government that are elected here. There's the
Yeah.
legislative and the executive. Okay, and I interrupted you because you were going to say, with respect to the district court, a big loss and a huge case in terms of what it means for, you know, thousands and thousands of federal employees. Now it's up in the Ninth Circuit, which is where I think I cut you off.
Oh, yeah. And then the Ninth Circuit ruled this week upholding the district court opinion. So I assume the administration will take this to the Supreme Court, but that's a big, big development in this case, because the case is, in some ways, it even swamps a whole bunch of other cases because it takes care of all of them.
Yep.
So that's the second one. The third one is in the same theme, separation of powers, congressional authority, which is Judge Tanya Chutkan in the D.C. District Court denied the government's motion to dismiss the case. And she did so on the grounds that the plaintiffs...
And which case is it?
So this is a case that would basically says that Elon Musk is operating in a position that's not constitutionally legitimate, and that Doge itself has been created in a way that's not constitutionally legitimate. So they're exercising authority that they don't have.
Right. And
huge,
just to remind our listeners, this is the case, and this happened not just in her case, but also in another case out of the Fourth Circuit, where there were various representations about who was running Doge, and Judge Chutkan dropped a footnote basically saying, hey, you got to pay attention to what you're telling the courts, because, what you're saying about, Elon Musk isn't really in charge, directly contrary to what the President of the United States said. It reminds me of Judge Boasberg asking the lawyer for the government at one point, are you saying that the president is lying?
Yes.
Which,
Yes.
obviously a lawyer for the government can't say yes. So, anyway, so that's a huge case, because obviously Doge has had enormous implications and ripple effects, and something that is, I think, very concerning to a lot of people who care about privacy is the access to data. And that's one that is going to last even apart from Doge, is this idea of trying to collect data. This is one where you and I are aware of this from our prior stints in government, but there are a lot of internally imposed restrictions on data and what you can do with it and who has access to it, precisely so you don't have sort of one-stop shopping where it's like, oh, we know everything there is to know about Ryan Goodman all at once, and that, if you're in the FBI, that doesn't mean that you automatically know what the IRS knows. In fact, there's all sorts of protections for that, as well as for sort of health records and things like that. So there's these efforts to sort of, it seems, obliterate those kinds of distinctions. And for people who are listening, we both teach national security law, and we have a lot of students who are very concerned about that happening in the private sector with tech companies. And this, in many ways, is sort of the government sort of analog to that, which is this idea of creating these full dossiers, sort of ignoring the Privacy Act, which is supposed to create these restrictions on need to know.
Yeah, and on page 7 of Judge Chutkan's opinion, she has these paragraph after paragraph, indented paragraphs about all of the actions that Doge has been doing, that the plaintiffs, which include attorney generals from multiple states, have brought to the court's attention. And that's one of them. And just to identify the other ones, it's just incredible the amount of power that Doge has been, and Musk has been exercising. So the other ones that are in her bulleted list are controlling expenditures and disbursements of public funds; 2, terminating federal contracts and exercising control over federal property; 3, binding the government to future financial commitments without congressional authorization, like the Fork in the Road plan; 4, eliminating agency regulations and entire agencies and departments; 5, directing action by agencies; 6, acting as a principal officer unsupervised by heads of department; and then 7, the one we just discussed, obtaining unauthorized access to secure databases and sensitive information. And I think for me, the big question is also, let's say that at the end of the day, this court litigation results in a final determination that is upheld on appeal, that Elon Musk has been exercising power unconstitutionally because he should have been appointed with confirmation by the Senate. That's the theory of the case. And Doge itself, in terms of the executive order, basically created an agency without Congress. So neither of them should exist. And then all of their actions were ultra vires or illegal, essentially. And then the question for me is, what shoe drops? Like, what is the remedy? Is this the kind of a case in which there'll be arguments made that the actions that they took have to be rolled back or invalidated because they were taken by somebody who's not constitutionally appointed for the position that they held?
Yeah, and whether it's sort of no harm, no foul, and is there a way to have gotten this information in a proper way such that that can now be instituted so that they don't have to do that rollback? And then if they do have to do that rollback, do you trust the government enough to do that with reporting to the court? Or do you essentially appoint a special master to a term that Judge Chutkan and I think our audience knows very well from Trump when he was a candidate, and there was a special master out of the Judge Cannon case, but you could have a special master appointed to sort of oversee that rollback to make sure that it is being done.
Yeah, and also just for folks thinking about the Judge Cannon cases, I also think about the Cannon holding that Jack Smith was not lawfully appointed as a special counsel, which would invalidate the actions that he took, such as indicting the former president at the time. So to me, that's also kind of a very similar analog to, well, what if Elon Musk was not properly appointed? Then his actions might have similar results. Yeah. Okay.
Okay. What else you got?
So, okay. So those are my three. I have additional ones, but those are the three big ones because they're three huge signature policies by the administration.
How about I'm surprised. I'm surprised given that we both are working in academia and I've worked at a law firm as well. What about Harvard and the never-ending seems litigation by law firms that are challenging the respective executive orders? There were, as people remember, there were 5 executive orders with respect to law firms. One was rescinded, the one with respect to Paul Weiss, after they caved and agreed to essentially pay, quote unquote, that is dispense sort of $40 million worth of pro bono work for sort of causes that would be consonant with Donald Trump's policies. So that left 4. And to my mind, you have sort of both some really interesting continued action in those cases, because I think now 3 of the 4 executive orders have now been conclusively found by the district courts to be null and void in front of 3 different judges. And so that is the Perkins-Coie executive order, the Jenner and Block executive order, and the Wilmer-Cutler executive order. We're just waiting for the final decision with respect to Sussman-Godfrey, which was the latest in time. So it makes sense that that hasn't come out yet. I think we're all expecting it'll be the same result. The main issue there was a violation of the First Amendment. And then with respect to the Harvard cases, there have been temporary restraining orders and sort of essentially a pause put in place on the sort of ongoing attack on Harvard by the administration and principally by the Department of Homeland Security in various iterations. So to my mind, and again, maybe it's because I come at this from a law firm academic sort of perspective, because that's, you view it from where you sit. I thought those were really big losses. And I think one of the things that's really interesting about the law firm cases is I'm not so sure that the government is going to appeal.
Yeah, I was going to mention that too. They haven't appealed the other 2.
Exactly. And then I wanted to talk about something really quickly, just to tie them all together in another way. We've talked a lot about executive versus congressional authority. With respect to Harvard and the law firms, it's very much about the First Amendment, not about sort of congressional versus executive. But I wanted to just say something very, very quickly, which is that the judges who are ruling this way, the sort of panoply of losses that you laid out and we've been discussing, are not from so-called liberal judges or exclusively from them or exclusively from judges appointed by Democrats. You have a whole array of judges, and there are various sites one can go to that sort of point out the enormous spectrum of judges. You have judges who are appointed by Bush, by Reagan, by Trump himself in his first term. And so the effort to vilify the courts as saying that these are unelected, out of control judges who are just liberal is just not factually true.
Yeah, and to pile on the same way in which you're saying, one in Harvard, it's also the judge converts her TRO to a preliminary injunction on Thursday with respect to the DHS's targeting of Harvard's ability to take in international students. And one more First Amendment case that's not necessarily about congressional versus executive branch power that goes down the same line of First Amendment issues from this week is the Mahmoud Khalil case of the Columbia student who Secretary Rubio declared he was a threat to U.S. foreign policy and therefore needed to be removed from the country. Michael Farbiage, the judge in that case, finds that the statute is unconstitutionally vague on First Amendment grounds, which is similar to a decision that Trump's sister had taken previously, though her decision was vacated for other reasons, I believe, by Judge Alito at the time on the appeal. But this is another important First Amendment decision by judge, happens to be Judge Farbiage. And it's also just interesting for people to understand, like, Judge Farbiage is a new judge in the court. And yes, he was appointed by President Biden, but the margin, I was just looking it up, was, I remember it, and I just wanted to get the exact number, 65 vote margin in the Senate. And I recall the nomination hearings and the like, and beloved, it seemed like, by Senator Lindsey Graham, among others, because Michael Farbiage has a background in national security law and things like that. He's not a lily-livered liberal or something of that nature. So it's just time and again, just judges with great credentials, nonpartisan, non-ideological in these senses of the words, and again are repudiating Trump administration policies for overstepping either in terms of executive authority or the First Amendment. So those were the big ones for me. So this first cluster and then the second cluster of First Amendment ones. There is a win for the Trump administration this week that we both decided we wanted to.
It was
big. Very big, huge.
And you know why it was big? Because just in terms of the number of people affected, I won't say it. Yeah, actually, I will say it. It kind of swamps everything we've been talking about in some ways. Obviously, you could say the academic attack or the attack on law firms. You could view those in a small way, but in terms of their chilling effect and what they could mean for the society at large, it's hard to even categorize. I mean, they're huge decisions. But this has sort of an immediate effect on, you can't even say tens of thousands. It could be hundreds of thousands of people. So what happened there?
So this was the ability of Secretary Noem at DHS to rescind the legal status for hundreds of thousands of people from Haiti, Nicaragua, and Cuba, and their status being called a TPS, or temporary protected status, that they would face danger if returned to their home countries. And it was highly predictable after the Supreme Court had already made a decision like this with Venezuelans earlier this month, temporary protected status, allowing her to rescind their status while the case is being appealed. I do think it signals very strongly that the court is going to decide in favor of the government eventually, because it's in some ways shocking that the court did this. Because in the evaluation of what's the most equitable thing to do while the case is still being litigated, you would have thought that the extreme irreparable harm to these individuals would outweigh other considerations, and the court would do the exact opposite, which is keep the status quo in place, keep them under protected status while the case is being litigated. So it may be a signal that the court, and including a supermajority of the court, is thinking there's some infirmity below in the district court opinions, like jurisdictional or otherwise, that will be strongly in favor of the government when this ever gets to that point of deciding the ultimate merits.
Now, what it means, just for people who are thinking, well, what is the effect? It doesn't mean that these people automatically can be removed. They do have other potential legal charges there's sort of legal defenses that they could bring. For instance, if you were going to be removed to country A and you could establish that you had a legitimate fear of persecution going there, you would normally we're now in a hypothetical world. That's my catty comment. But normally you'd be able to go to court and you'd be able to prove that, and then a court would decide whether you could be removed or could not be removed to that country. So there is that individualized ability, but it requires the government to afford you that opportunity and not just ship you off to, for instance, El Salvador and shove you in a prison and then say, I'm washing my hands of you, CEG, Abrego Garcia, and many, many other people who are still in El Salvador, in spite of the fact that the Supreme Court has said 9-0 that their due process rights were violated. It also means, even though you might have that potential argument, it means you have to raise it individually. It's not being that this gets rid of sort of the policy of giving this whole class TPS status, temporary protected status. So when you do that and you require that sort of individual determination, it means each of these people has the burden then of going to court, potentially trying to get a lawyer, making these arguments on an individual basis. So that's very, very hard, because there'll be a huge percentage that won't be able to do that, won't know to do it, won't be able to meet their burden, et cetera. So huge consequences, even though there are some individualized defenses that could be raised going forward.
Yes, and I think there's also a outside of law, a political layer. And I want to be careful here, because I don't want to give, in a certain sense, like anything approaching legal advice as to what the current status is for people who have TPS, because it's now the discretion of the DHS and Secretary Noem as to what they will do. And the reason I'm pointing this out is twofold. One, I had a communication with a lawyer who's heavily involved in this litigation, and the DHS website on TPS status for Venezuelans, after the Supreme Court ruled in favor of DHS on that, might in fact suggest that there's still this window in which they will be able to retain TPS status. So that's one, people should consult immigration attorneys for that, but that's one piece. And then second, the New York Times reports, and other news outlets as well, subsequent to the Supreme Court opinion, Republicans in red states are very upset about the idea that Venezuelans who are legally present in the United States might be attempted to be thrown out of the country by the administration, and including especially in Florida, that Florida Republicans are now trying to appeal to the Trump White House and the administration and DHS to stop this in a certain sense of the communities and economies that are predicated on the notion that these people have been here legally and have become parts of communities and things like that. So, watch this space in a certain sense.
Yep. So this is probably a really good segue to the sort of the final thing that we wanted to talk about, which is not a case, but is this idea of remigration, this idea of having a remigration policy. As I understand it, it's sort of a term of art that was coined in Europe with the idea of essentially it's sort of like what Elon Musk, I think, was quoted in saying when he was in Italy, which is like, Italy is for the Italians, South Africa is for essentially the white South Africans, France is for the French. And it's sort of an anti-immigrant idea where the idea is to remigrate them out of the country. It's part of the same thing that animates so much of everything we've been seeing since January 20th, the Abrego Garcia case, all of these cases where there was a lawful way to do all of this that was not taken by the administration, in my view, and has been found by the courts. Because that's sort of the underlying animus that you're seeing, but it's so antithetical to, I mean, I know this is more of a political statement, but, you think about Emma Lazarus and, both of us work in New York City and have the Statue of Liberty at the tip of Manhattan about give us your poor and huddled masses, where America for generations has been a home to immigrants and in fact is a nation of immigrants, but for indigenous people. And I clerked for a judge, just to I'm going to end with my high horse in one moment, but I clerked for a judge who, like many district court judges, federal district court judges, had naturalization days where new citizens would be sworn in, and a federal judge does that, and the room is filled with new citizens who have filled out all the right paperwork and taken oath, and he would give them a speech, but one of the things that he would say is, he'd say, many people think of America as a melting pot, but don't forget your customs and your traditions and your language and where you came from, and that immigrants are the glory of the United States, and makes us so different than other nations because our history is the conglomeration of immigrants to be here. I mean, obviously, there's a lot more to it because of there's also a very negative history with respect to indigenous people and many others. But that idea of welcoming immigrants and that actually is the fiber of who we are, it reminds me very much, just to tie it to the Harvard case, with Harvard saying when the Department of Homeland Security was trying to say, we're going to rid you of international students, and Harvard in its papers said, Harvard without its international community is no longer Harvard. That it's part of the fiber of who they are.
Yep. So, and to me, when I read the first report that the big reorganization plan that Marco Rubio sent over to Congress for the State Department had in it a quote-unquote Office of Remigration, I almost fell off my chair. There's so much noise, there's so many bad things that are happening in the country, but to me this is in a entirely different register. It's very, very troubling. It's almost as if, it's not the exact same thing, but it's almost as if I picked up the paper and it said that the reorganization and plan includes a new Office of White Nationalism. Remigration, the terminology that is being played out in Europe, is white nationalist. Explicitly, it's about sending people back to their supposed home countries outside of Europe who are non-white. And it's interesting you mentioned Italy. So Italy earlier this month held a remigration summit. And this is what it's about. And The first news outlet to report on it as a kind of a scoop in a sense was Wired. Then the second one that I saw that I think might have come second was Mother Jones. There's a very good piece in Mother Jones about the Office of Remigration and giving you the context for it. Axios has now also reported. I wish there would be other mainstream news outlets highlighting this because it's a significant change. And I think there need to be serious answers to who came up with this frame. In the Mother Jones piece, they mention, just interestingly, a 2019 Associated Press article reporting on this notion of remigration. And I thought it was good because it's the Associated Press, it's 2019. They're maybe more willing and able to be very frank about what these mean. The Associated Press's quote of telling you, the reader, what remigration is quote, a chilling notion of returning immigrants to their native lands in what amounts to a soft-style ethnic cleansing, end quote. And the Associated Press's headline of their article was titled, Taboos Fall Away as Far-Right EU Candidates Breach Red Line. So to see that happening in Europe, and Germany's AfD party has embraced remigration, and they're the far right, some call them a neo-Nazi party of Germany. That's their notion of remigration. I assume that we might see some backpedaling by the administration, like, oh, that's not what we meant by it. But my God, coming off of the remigration summit in Italy, you say the word remigration in Europe, everybody understands what you're talking about. So to me, I'd really like to know whose brainchild this was. And if
in some ways,
Marco
though,
Rubio would like to come to Congress and answer for it.
In some ways, I find this to be actually just saying out loud what is happening. That we've talked in today, and we've talked in our prior weekly discussions about the immigration cases. Well, the people who are being extracted from this country are, I would say, virtually all, correct me if I'm wrong, or you have different data, people of color. We are not talking about, sort of white people from sort of so-called Western countries. I'm thinking of the countries that Trump, appears to value to some extent. But he, so not from sort of his background, sort of German background, whites. And if you think those are so that you have these people in Black and brown communities of non-Protestant traditions being extracted, but you also have the people who are being given exceptions to come into the country are white. And so you saw that, which is that the whites who were supposedly or purportedly discriminated against, as opposed to the people who did the discrimination, were allowed in to the United States. So, I mean, to me, this is, I agree with you that it is different in register, but in some ways, I think it's fortunate that it's just out loud, that this is what's going on. That it's not like you can't just deny it and have to look at the data. It's like they're putting it right out there. It's not just that it's de facto happening, it is our intent to have this happen.
Yeah, and as you and I discussed in a recent video conversation, the particular example that you're talking about, while there's a shutdown on refugee programs that are being litigated, we just talked in the last bit here about denying temporary protected status to Venezuelan, Haitians, Cubans, Nicaraguans. What we talked about in one of our most recent conversations is the very animated, aggressive embrace of white Afrikaners from post-apartheid South Africa, as though they are refugees in need of being flown by the United States into the country and greeted by a senior State Department official, and being told, and that we're being told as a public that the reason that they were chosen is also in part because they could better, quote unquote, assimilate. into the country. So so we talked about that before, and we're talking about it again. And I agree with you. It's of a piece, and it's being more explicit about what's going on.
Ryan, it's great to talk to you. One thing that we want people to think about is to send us questions. Obviously, we've talked a lot about other weekly shows we've done, so people can obviously listen to those, but they can also raise questions in the comment feature. They can raise questions to each other, but also to us, because we will be looking at that and then either answering them directly or incorporating them into our discussion, so that when we see that there are topics that people are particularly interested or questions, we will make sure we try to get to those in our future discussions. So even if we you don't see us anymore, feel free to continue the conversation, and we will pick it up certainly by reading about it and then picking it up next week when we talk about the news of the day.
Great. Yeah, I look forward to the comments.
Take care.